Good afternoon, or good evening, chat. Why am I zoomed in like a motherfucker? Damn. All right, well, there we go. Whew. That was weird. Not funny at all. Just weird. Just weird. Anyways, welcome to the show tonight, guys. It's Tuesday. Wow. I was just, no, there's no way in hell it's Monday. I just went through 2 Mondays. I'm going to jump out the window. No, it is Tuesday night. Welcome to the show. Welcome to the show. My name is Sean, also known as Potentially Criminal. I am an attorney in the Cleveland, Ohio area. And tonight it's the saga and the story that I know I'm not the only one who's going to be taking a look at this. I think Melanie Little took a look at this already today. And it was like I told you guys over the weekend, we were going to go into this. I guess it's kind of hitting everybody at the same time. Aaron Spencer. And it's the state of Arkansas versus Aaron Spencer. And we're going to get to the story of what happened here and what this is all about. You know, and this is a true miscarriage of justice. And could it be that this guy really did commit murder? I don't think so. I mean, based on the thumbnail, I think you guys can tell what I'm looking at here. You know, dude took out the trash, and he took it out in a very personal way, because he had a very personal issue with that trash. And yes, it's not that Aaron, chat. It's not that Aaron. We're going to get to him in a second here, but we got to let some people catch up. Tech Guy Celsius says he's fat. He's zoomed in. He's overexposed. Cyanide Cologne says, Aaron, another win for the toe. No. Not at all. Not at all here. I did think it was funny, though. Somebody said, do you think this Aaron ate goo too? No, this Aaron does not look. This Aaron does not look like he eats goo at all. It's a very manly version of. It's a very manly man named Aaron, and we're going to talk about what this is. It's going to make you mad. It's going to make you mad, and we're going to get to all of the floppy sloppy. Hold on 1 second. We're going to get to what I think is prosecutorial misconduct. And then we're going to get to what I think is some additional action here that I don't think is fair. I don't think is proper or should have happened. And we're going to get to these issues here. And it's it makes your blood boil. Makes your blood boil. You will be very, 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 very pissed off. You'll be very pissed off. And hold on, why is this not working for me like I want? Okay. So we're going to start up. Oh, hold on 1 second. Yes, we also have another dog. You guys are going to hear barking. Louie from before. See if we can grab him. Hey, Louie. Come here, Lulu. Come here, buddy. Hi, Louie. Come here. Come here. Come here, Louie. Louie. There you go. Right. Right here, Lou. Right here, buddy. See if I can bring the camera down a little more for him. Lulu. And he won't. Louie. Hey, oi. And well, there you go. You saw him. And then real quick, like normal, we've got, come here, Clyde. Hi, buddy. You're like, save us, fat man. The crazy dog is back. Yeah, we had a emergency dog sitting situation. So Clyde's like very, very chaotic friend is here. So is that it, buddy? Huh? He's like, I'm out of the way. Can you give it a woo? Ooh. Oh, he almost. I thought he was going to for a second. Clyde won't a woo because you keep messing up the towers. That's very true. Katie says, I want to adopt a Clyde. Well, you're going to have to find him. You got to go look. There are guys that are Clydes all over the country. You just got to look around. Look around at your shelters. You'll find a Clyde. All right, Bubba, I'm going to set you down because I got to get to work. Okay? Hey. Oi. He wants to know what's going on out there, so. All right, I'm going to set you down, buddy. Did you get dirt on me? No. Here. Shh. I'll get you a Clyde treat here, buddy. There you go. Louis doesn't know about that one. All right, chat. Real quick, 2.0 wanted me to get to the present here. Remember, coming up on the birthday here, so let me grab something real quick, and I'll be right back. I'm going to go grab it. All right, chat. Sorry, I had to go grab it off this pile of just the never-ending pile of stuff that 2.0 has gotten me at this point. Still funny though. Some of it's just stuff we need. So I still think it's funny that at times this happens. So, all right. Yes. Sean needs the XXXL Baldo. Yes. All right, guys. Well, here's something for 2.0. We'll open it up. I can't tell what it is, but I can see writing. All right, let's see what we got, chat. Ooh. Oh, this is be nice. This will be nice. Hope it's a capture card. Well, Clyde ever tried KFC? I'm pretty sure we've given him pieces of KFC before. This is just like kind of what Mean Copium got me. If you guys remember, he got me a Waterline series Yamato battleship. And this is the USS Yorktown. Now, they had a second Yorktown carrier. This is the one that went down at the Battle of Midway. So this would be that. This would be that, meaning it's a Waterline series, meaning it doesn't have a full hull, which is kind of nice because that's a lot of work to work on a hull. So this is an aircraft carrier from World War II. It went down, like I said, it survived the Battle of the Coral Sea to be turned around in record time from the damage it suffered there to go to the Battle of Midway, help assist in the ass whooping that we gave at the Battle of Midway, and then was heavily damaged at the Battle of Midway. And then eventually, as it survived, it actually survived the Battle of it survived the Battle of Midway, and then was sunk in the aftermath of the battle by a Japanese submarine because it was getting towed home for more repairs, and it would have been salvageable. It would have kept going. CV5 would have kept fighting had the Japanese not sink, had a Japanese submarine not sink and getting towed. So, yeah. So, and anyway, we're going to open this up real quick because I kind of want to see what's in here. Where is... where are my... Where's my razor knife? That's not good. I'll just use these real quick. I'm curious to see what's in here. Sorry, Chad, if you're new. Like, we're going to get to Aaron here in 1 second. We're taking care of this, so... And this is a 1 It's a 19,800 ton, 247 meter long ship. It's a 1/107th model, meaning that everything is 700 times smaller than the real life version of it. So they scaled it down because otherwise, we wouldn't be able to do anything with it. Um, Sika Yoroku battleship Shipu. So, surprised it hasn't gotten into Azure Lane for the anthropomorphic ship waifus. I don't do that stuff. Yes. Yes, that sub was later sunk by the United States. Yes, we got our fucking revenge. Yeah, so here you go, chat. It's a waterline model, so this is the hull. And you can see those cuts in it are the elevator decks and the elevator positions. And I think does it come with any planes? Oh, it does. It comes with a bunch of little planes. Oh, it comes with a bunch of little planes. They're so cute. Focus. Comes with a bunch of little bitty airplanes. So there we go. There we go. It looks so cute. Does this come with photo etch too? No, but it's very very, very good definition. Ooh, buddy. Have you ever watched the YouTube channel Operations Room? Yes, it's a very good channel. It is very good. I will say there is a YouTube channel out there called Montemayor. He's like a Hispanic. I think he's like a guy from, I don't know where he's at, but he does a really good breakdowns of some of the battles out there. Ron, how you doing? Ron and Tony saying, what, no squids and white suits? No, and I got your messages. I am going to take a look at that thing for you. I haven't had the chance yet, so my apologies on that. I've been underway on the USS America and the USS Forrestal, and the America is much smaller than the Forest Fire. Yeah, because the USS America is at Essex class, I think. Hold on. USS America. Oh, it was a Kitty Hawk class. I'm sorry. It was, well, there's this. Yeah. I thought wasn't there an Essex class too? I mean, there's an amphibious assault ship USS America, but there was a carrier USS America. It was one of the Kitty Hawks built. I thought there was a previous, like there's an Essex class USS America too. No. Some reason I thought there was. But yes, the Kitty Hawks were a subclass of the Forrestal class of carriers, like the Saratoga, the Constellation, and then the John F. Kennedy were all kind of in that classes of things. But yeah, there were quite a few Forrestal class carriers. So they were like the first original super carriers. Like the Saratoga and the Ranger were also in it. Are the planes 107 scale too? I think technically they are. It wouldn't work. The America was in Norfolk in the 90s. Oh, cool. Hold on, chat. I'll take you up here. Thank you, babe. Okay. There's a Battle of Jutland video that is really good, but the name of the creator escapes me. There's a couple of good ones. And Jutland is one, if you don't really understand what happened there, that's like the only time battleships did battleship things in the modern era. It's a really cool battle. And it's interesting because the Germans got scared and they ran back. But it's very interesting, like, what happened in the Battle of Jutland and how it broke out. If Sean does his models on stream, aren't they tax deductible? I mean, I don't really know how far the IRS would let me go with that because I'm doing it also for personal enjoyment. But I'd love to be able to do that. I would love to be able to do that. It's like, no, all this model paint, all this stuff. So, so, anyways, guys, that is it. Thank you, 2.0. Thank you so much, baby. Babe, thank you so much. That is very nice. Did you get... That's going to go perfect with the one meme put together for me. So I think it'll be very cool. Very, 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 very cool. Travel channels write off their flights. Yeah, but those people are... Yeah, well, anyways. YouTubers write off more retarded shell time. I know, but I don't really want to risk getting audited. But we'll see. We'll see, chat. Anyways, let's get going. Talk is cheap. And we are burning daylight. We are burning daylight. So... Here we go. Does the Yamato come with lots of holes in it? No, I have to add the holes. I have to add the holes. Also, I noticed you guys are all getting... yes, 2.0 is awesome. 2.0 is so amazing. 2.0 is very, very amazing. Ego.exe is saying, I found it. It was Draya, 1916. Dracvanel is also a very good one. I mean, there's a lot of good... There's quite a few good naval channels out there. You just got to look for them. Just got to look for them. But yes, I've heard of I like him, but I like Drac a lot, or Dratch a lot. So, anyways, let's get started, guys. So we have our two people, and first of all, we need to start off with this guy, Michael Fosler. Michael Fosler is 67 years old. Or what do I say he is or was? Because he dead. He muerto, as I put there stamped on his head. Muerto. Michael Fosler was accused of multiple crimes in Lono County, Arkansas. So what happened there? Well, a lot of things happened. He got charged with the internet stalking of a child, multiple counts. He got charged with sexual assault, sexual indecency with a child, electronic facilitation of child sexual abuse, pandering or possessing medium depicting sexual conduct of a child. Quite a bit. And like, just look at this. Look at all this. Man loved his cheese pizza. Man loved his cheese pizza. So that's a man's cheese pizza there. Okay. I do like, so what do we know about his case? Well, there was a order to seal the affidavits, and that was granted because the court having considered all facts, the affidavit shall be sued due to the minor victim. So the judge sealed the affidavits, the criminal complaint. We don't know anything about it right now. It's been sealed. But as you can see, his case was kind of chugging along until we get to October of 2024, and then we have this. There is a order to seal a death certificate. You're like, okay, well, what happened to this guy? Well, he got killed. You're like, well, that sucks for him. Yeah, I know it does. It sucks when, a guy who's accused, and remember, yes, he's innocent until proven guilty. One of the conditions of his case was don't go near your victim. Pretty standard one, right? Stay away from the victim. Stay away from your victim. I think we can all agree that's a very reasonable and a very much expected court order. You have to have no contact with your victim. I mean, I think that's pretty good. Okay. Now, what happened? Well, the victim is Aaron Spencer's teenage daughter. And on October 8th, Aaron awoke or something happened and his daughter was gone. From the house. So as a result, he's like, well, what the fuck? I'm going to go look for my kid. He started driving around. And this is Aaron. If you haven't seen him, this is Aaron right here. This is Aaron Spencer. So he gets in his car and starts driving around. The dog was barking. Yeah. Dog started barking and he ran around looking for his daughter. Started driving around and he found Michael Fosler's car. And guess who was in Michael Fosler's car? Guess who was in Michael Fosler's car? Aaron Spencer's daughter. Aaron Spencer's daughter. The one he's not supposed to be in contact with because he's alleged to have diddled her. Yep, Michael Fosler, that's the guy. So anyways, Aaron starts chasing him down. And at that point, Aaron stops them. There's some sort of altercation or scuffle or something. And then sadly, and actually, we can't even call it sadly. Pretty much what you kind of hope happens. Michael Fosler is found dead, shot full of fucking holes. So now, real quick, 10K views says the daughter kidnapped or willingly traveled with the guy. She's a minor. She has no. He's a pedophile and he's abducting his victim. Whether he lured her outside or he snuck in and drug her out, it doesn't matter. There was no reason for her to be in a fucking car with this man. It doesn't fucking matter. It does not fucking matter. There's no reason he should have had this fucking kid in his fucking car. I don't care if she was 17 years old. I don't care. He shouldn't have a fucking child in his fucking car. Doesn't fucking matter. Doesn't fucking matter if she joined up and said, hey, let's hang out, bro. No. Danielle says it's kidnapping. It's abduction. I'd argue it's abduction. It's kidnapping, whatever you want to call it. Yeah, she's barely 14. So, yeah. And she can't consent to him breaking the court order. So, after that, and I should point out that Fosler is a former police chief in Lono County, it appears. Very quickly afterwards, the Lono County prosecutor's office, staffed by these faggots, specifically Chuck Graham, the prosecuting attorney. This cuck right here. It's like the type of man who would protect a pedophile. It says you can read some links here about things. Justice isn't served until victims are. Oh, isn't that funny? Isn't that funny? But anyways, Lono County, Arkansas, you can see the about, who we are. You could find here. Here's the entire whole staff. Look at all these people. Here's the head cuck. Here's one of the other cucks. Here's a dumb whore. Here's another dumb whore. All these people have to be okay with this prosecution, but cucks and retards everywhere they go. So, yes. And it says how justice works. Well, here's how they believe it works. Crime committed, like fucking kidnapping of a child. Yeah, the police report and they investigate the case given to the prosecutor. Okay. Further investigation needed, declined to prosecute or file a criminal information. Now, here's the thing. A criminal information, and this is a critical thing in... This is a critical thing. You could file informations in some states. You could charge people without a grand jury. But anyways, this is the Lonoke County Prosecutor's Office. This is their head guy, Chuck Graham. I mean, look at him. He probably helped Fosler diddle kids. I bet he did. Look at him. Look at him. Look at him. He probably enjoyed it. He probably enjoyed it. You guys see the screen now. You know, the tamps have been pamped. It's all there. They charged Aaron in an information. Now, why is this such horseshit? Because this is not an indictment. It doesn't go to the grand jury. Okay? This is not through the grand jury. And this is why states should have grand juries for felonies. I've told you before, guys, in Ohio, you can only be indicted for a crime, for a felony, by the grand jury. You can only be charged with an information if you consent to it. So if you don't consent to the information being filed, you don't waive your right to a grand jury, you don't get charged. Sorry, that's how it works. But in Arkansas, the prosecutor himself comes in and accuses the defendant, Aaron David Spencer, of second-degree murder, or murder to a Class A felony. And what do they allege? That on or about August 8, 2024, he did knowingly cause the death of another person under circumstances manifesting extreme indifference to the value of human life. I don't know, shooting a fucking pedophile sounds pretty fucking based. Murdering a guy who abducted your fucking daughter sounds pretty fucking based. Michael Fosler against a peace and dignity in the state of Arkansas. And then they charge him with an enhancement because he used a firearm for an additional period of confinement of 15 years. Signed by Chuck Graham, the prosecuting attorney. Look at this fucking Russell Greer tier shit. What a cock. What a cock. What a cock. So he got charged. He got charged with an information. Shortly after that, things got a little crazy. First of all, and this is a little weird to me, and I need to look this up a little more. Aaron has attorneys, and in December of 2024, they filed a notice of intent to raise justification as a defense. Now, under some state laws and under certain criminal rules in some states, you have to raise certain defenses by motion. So, for example, in Ohio, if you're going to raise alibi, you have to raise it by motion. If you're going to raise self-defense, you have to raise it by motion. So what do? So through his attorneys, Aaron Casanelli and Michael Kaiser, they put his notice of intent that he does intend to raise justification as a defense under the state code, and his intent to raise justification as a defense in this matter. Justification and provocation, yes. But ultimately, self-defense is applicable. You're allowed to defend yourself and others. And this is something, chat, where abduction of a child, yeah, that's an inherently dangerous and violent felony. We talked about these before. In law school, you learn they're called BARC. Burglary, arson, rape, robbery, and kidnapping. Those are the 5 originally inherently violent and dangerous felonies that are out there. There are other ones, but those are generally the inherently dangerous ones and inherently violent, that people get killed in burglaries, they get killed in robberies, they get seriously injured or killed during rapes, during kidnappings, and arsons. So, yeah, he was in the process of Fosler's in the process of kidnapping this kid. I'm sure he wasn't just going to take her and not diddle her. either way, immediately afterwards, the prosecution, John Huggins, he's the chief deputy. I'm sure he has the frequent points card. I'm sure he's the platinum club member at Hedonism too. It shows up every year for Ace of Spades weekend or Queen of Spades weekend with his wife, or maybe he goes by himself and dresses as a woman. I don't really know. But they have a motion for a gag order they file, and this is December of 2024. Here's what happens. So Aaron Spencer's charged with murder in the second degree. They say Aaron Spencer's arrest has garnered media attention and coverage throughout Arkansas and the nation. Yeah, you prosecuting a man for murdering a pedophile who abducted his child is going to get people to notice. It's going to get people to notice. Can't go, well, I didn't know this was going to happen, boss. Like, how'd you not know? How did you not know? How did you not know? How did you not know this was going to happen? But once again, we'll keep talking about the cuckers. You know, Chief Deputy Prosecutor Cuckins. Chief Deputy Prosecutor Cuckins. He says, additionally, details of his arrest are spread via social media. Okay, so what? Defense counsel issued a press release. So what? Defense counsel has given television interviews. In one interview, counsel stated, we feel confident this community is going to come to Aaron's side because every one of them would have done the same thing for their child or their neighbor's child or a member of their family. We look forward to the public being more involved in this process, certainly more than they were today. And what's that referencing, chat, this last part? Aaron Spencer basically had a secret arraignment. The public was not allowed to attend. But oh no, they want more public involvement, screams the prosecutor. The state argues the dissemination by any means of public communication, any out-of-court statements, may interfere with the rights of the defendant and the state of Arkansas to receive a fair and impartial trial. You are not entitled to a fair and impartial trial. You are not listed in the Sixth Amendment. You are not entitled to a fair trial under the United States Constitution. You are not entitled. You are not entitled. And I don't even, you know what? We're going to do this. Arkansas Constitution. Let's see what the Arkansas Constitution says. The Constitution is Arkansas of 1874, which means this is because of Reconstruction, chat. Because, gee, what happened before 1874? There's like a war. The right to bear arms, jury trial, liberty of the press, right of the accused enumerated. Let's see here. Suspension, redress of wrongs, treason, imprisonment for debt, life, liberty, and property. I don't see it right here. So you know what we're just going to do? Fair. Control F. Fair trial. Hold on. So, yep, here we go. Right of the accused. In all criminal prosecutions, the accused, not the state of Arkansas. So, Mr. Cuckins, you are not entitled to this, sir. You are not entitled to this. It's not like when you go to Hedo with your wife and you jump in the pile and you start taking on those strapping young black men. No. You don't get any of that. It's not for you. It's not for you. It's not for you. It's not for you. The accused shall enjoy. So once again, this is just much more bullshit. The need to preserve the integrity of the jury pool is paramount to ensure the right of a fair trial to both the state and the defendant. Once again, you are not entitled to a fair trial. Guess what? The jury's not going to support This, like, you guys prosecuting a man for murdering a pedophile who is in the process of abducting a child. Why did he have that kid in the car? I mean, Jesus Christ, I can't wait for the jury to say not guilty, take this dude out to a steak dinner afterwards. Now, here we go. Listen to this. The state praises court order that no party to this action, nor any attorney or agency connected with this case, nor any judicial employee or officer of this court, nor any public official now holding office, but not limited to law enforcement officials, nor agent, deputy, or any of such persons subpoenaed to testify at this case. Okay. Shall release any purported extrajudicial statement, shall release any documents, make any statement. Okay. Express the outside the court an opinion, making any comment for public dissemination. Okay. Make any statement outside the court for public dissemination. Issue any statement for public dissemination as to the identity of any prospective witnesses. Okay. Make any out-of-court statements for the weight of the evidence. Make any statements for public dissemination as the content, nature, and substance of it. And these cucks want this granted. These cucks wanted that granted. That's what they wanted. That's what they wanted. So, what did we get? What did we get? Well, we got some straight up hillbilly bullshit. And what was it that happened, guys? What was it that happened here? Well, like I said, some straight up hillbilly bullshit happened. So December 10th, a couple days later, we get the order for the gag order. And says, in view of the apparent public interest in this case and extensive news media coverage, it appears to the court the dissemination by means of any public communication of any out-of-court statements relating to this case may interfere with the rights of the defendant in the state of Arkansas to receive a fair and impartial trial. Once again, this is such horseshit. You are not entitled to a fair fucking trial. You know, and this is where if I was the defense, I would have been like, these guys could fuck themselves. These guys can fuck themselves. This is just it's just absolutely horseshit. I mean, this is just such a horrible thing here. So, it's absolutely garbage what happened in this case here. And hold on here, chat. I'm trying to look for something. And this is where courts get wrapped up in this. They're worried about a fair trial. It's like, you're not entitled to a fair trial. So, like, you know, you're not entitled to any of this. And his defense brought up that they can't hide behind a fair trial because if they did stuff wrong and they were criticized for their awful decisions, there's been no proof that it's hampering a fair trial. They aren't entitled to this. And I would say this is something that if you guys want to know, and this is where the Aaron's attorneys bring this up, and I think like they deserve a fucking pat on the back for this. They point out that the state does not have an equally comparing right to a fair trial rooted in the Constitution. These rights belong to the people, not the government. And the public's own compelling interest in fair trials designed to end in just judgments. This is a right belonging to the people and meant to protect their interest. and not the prosecutor's interest in an easy conviction. And that's what this is. This is what this is, but we got to get back to Judge Hillbilly here. So, is the order of this court that no party to this action, and going through all of this, and now here's the add-on part, neither shall the defendant nor his family shall do any of the following. The defendant's family? You're going to gag everybody? And going through all of this, all parties in this defendant are under a gag order. You know, you couldn't write this out. You couldn't type this out. This order will help ensure all parties get a fair trial. Fuck you, you dumb cunt. Barbara Elmore. Fucking Hillbilly Jane. Just simple country folk in the holler. Sucking government dick. We gotta make sure we can prosecute you if you murdered one of our favorite pedophiles. We should check her hard drive too. The entire case is now sealed. We should check her hard drive. We should really check her hard drive, chat. How could she gag the non-party family? Yeah, I don't know. She's an expert on gagging, though, chat. She probably goes to Hito, too. She probably goes to Hito, too. Eventually, though, the Supreme Court of Arkansas had to step in. They had to step in. And they had to be the adults here, and they had to look at this judge, and they had to go to good old Barbara Elmore. Let's find her picture here. The Honorable Barbara Elmore. You know, Lonoke County. Let's see here. Is this her? I think this might be her. Here's Barbara Elmore. I think this is her from what we could tell. State of Arkansas for Lonoke County. There she is, chat. Cut glass with that jaw. So. Yeah, that's a forehead. That is a forehead. Wonder how many rusted out Camaros she's got in her front yard. I mean, she looks a bit mongoloid, so she's probably like, hey now, I used to help Mr. Fosler molest children. We can't talk about this none. So I'm sure she's got some problem there. I'm sure she's got some problem. She probably helped this guy molest children. That's why she's covering it up. Anyway, the state of Arkansas had to get involved. The Supreme Court's like, look, there was a petition for writ of certiorari granted, and ultimately the circuit court's gag order was vacated. They're like, all right here. This is fucking insane. So they talk about the whole case here. Oh, we didn't get to the press release, chat. We need to get to the press release from the sloppy tampon party here of the prosecutor. Which, I mean, I have no problem with the statement. So here it is. They talk about, you know, Aaron Spencer is a decorated war hero, veteran of the 82nd Airborne Division, All-American. You know, he's All-American and he's proud to be the fighting soldier for liberty. And a loving father whose actions protected his family. He's not a criminal. He would do what any father did and any trained combat veteran do. Protect his child from a predator. He took fucking action. He was decisive. He closed with the enemy and destroyed them. That is what he did. This predator violated his bond and, undeterred by charges, released on a low bond. And that was the thing. Michael Fosler got out on a dirt cheap bond that pales in comparison what was required of Aaron. kidnapped the child in the dark of night to continue his assaults. And apparently he's been a pedophile known for doing this for years. And his continued abuses culminated in his facing a father who finally stopped him. No matter what the prosecutor may do to Aaron, he was able to save his child, prevent this man's continued sexual violence from continuing. While the prosecutors made it clear his intent to send Aaron to prison, even targeting his use of a legally owned firearm, and in spite of his past experiences in combat in this country, it is not the prosecutor who decides justice, it's the citizens. Very true. We believe this country and this state will not allow this injustice. This community will not allow a father protecting his child from a sexual predator to be treated as a criminal. The repeated traumas Aaron's family has endured are unimaginable. It's sadly the prosecutor's decision perpetuates these horrors instead of protecting legitimate victims. And they say, we will stand up for our right to protect ourselves and our children and will not be deterred by this unjust decision. Please keep Aaron and his family in your prayers as they continue to heal from past events. And look forward to Aaron's day in court and ending this nightmare. Well, there you go, chat. There you go. The judge was the same one that gave him a bond, yes. Yep. The affidavit is out there. I've heard it's out there. I did not find it in time for the show. So that is so so the arrest affidavit says the affidavit mentions that they got a 911 call from Spencer, said he located the man and that Fosler is dead on the side of the road. He had no choice. And he basically says he turned around and chased him, and and apparently at some point he says that he tried to get his daughter out of the car and Fosler wouldn't let her. And he says that Fosler had something in his hand and he opened fire on him and then he pistol whipped him, which, I mean, he got mag dumped with a fucking Glock 19, chat. Fucking homie put in work. So that is really the rough issue there. I have not seen the full thing there, but it's out there somewhere. I did not get to see it yet. So temporary insanity, you don't even have to worry about that. I don't even think we won't even get to that, haystack fam. We'll get that. It's a good point though. But anyways, we're going to get to the Supreme Court here. They talk about the entire thing that happened. So we get to the court, and here's the thing. On December, they talk about all of this. On December 9th, Spencer filed a detailed motion, and they requested an open hearing. We want to have a hearing. And here's what happened. Without holding a hearing, the circuit court entered the order at issue. Noting that while there's public interest in the case, the court granted the state's motion with modifications. And the court further noted it was seeking a fair balance between the guarantees of a free press. And then it added, they go through here and they type it out. They don't just have it. And they point out the order included several handwritten notations initialed by the judge, including Spencer's family, which was neither shall the defendant nor his family. And it goes through all the options here, and everything that happened. All of that. The order goes on to require that a copy of this is attached to every subpoena and a redaction of any information violating the gag order from any paperwork related to the case that may be disseminated. The order would be in full effect, and this order will help ensure all parties get a fair trial. And this entire case is now sealed. That's not how that fucking works. And notice here, this sua sponte, meaning the court of its own accord, of your own accord, the court sealed the entire case. And the Supreme Court of Arkansas says, note that this order is nearly identical to ones we have vacated without written opinion in the Arkansas Democratic Gazette versus the state of Arkansas, a petition for writ of certiorari. Although the present order does not expressly apply to media outlets, the 8 prohibitions on speech and the 7 provisions for information not prohibited by the order use the same language as in the Arkansas gag orders. Arkansas courts should no longer use this apparent form order. That's how bad this is. We don't know where the fuck you're getting this from, but stop. Stop doing this. That's how bad this is. We don't know where the fuck you got this from, but quit using it. Quit using it. Quit using it. Quit using it, chat. Quit using it. So they talk about in February, Spencer filed in this court for a petition for writ of certiorari. There was a briefing schedule stuff done. Spencer also requested oral argument. We granted Spencer's motion to stay the proceedings in circuit court, took the cert, they said a briefing schedule, and granted the request for an oral argument. I want to hear that oral argument. I want to hear the bullshit there. Now, they talk about issuing a writ of certiorari. Remember, your state Supreme Court is not a court of right. Your state Supreme Courts are hard to get into. You need certiorari. It's not as tough as the United States Supreme Court, but it's still pretty tough. Because you've got every Tom, Dick, and Harry appealing shit to your state Supreme Court. Just from your state. But think about all the stuff the Supreme Court of the United States has to turn down. A lot of stuff gets turned down that may be legitimate for state Supreme Court cases. And even then, for example, just so you're aware, like for Ohio, for example, like I said, I can only do Ohio. You have to file special things a special way. And you have to provide kind of like you could provide a 25-page like preview of your case. So you have to craft that and hope they take it. And they could still turn you down. You could put all kinds of work and still lose. But they point out that a writ lies only when it is apparent on the face of the record there has been a plain, manifest, clear, and gross abuse of discretion, or there's a lack of jurisdiction, an act of excessive jurisdiction on the face of the record, or proceedings are erroneous on the record. And this court has held that a writ is appropriate when a prior restraint on speech is a plain, manifest, clear, and a gross abuse of discretion. Oh, they're just saying barbs. Barbara Elmore. They're saying bitch. They're saying honey. Honey, whatever you thought you did here, honey, it ain't working. They're saying, honey, this ain't working. This ain't working, honey. So the analysis. The state responds, the state claims the circuit court's order was in constitutional limits, protects the integrity of the case, ensures a fair trial. And they say, for the reasons below, we hold the circuit court's action was on its face a plain, manifest, clear, and gross abuse of discretion and in excess of its authority. That's pretty bad. Like, it's that fucking bad, chat. It's that bad. And, the state tried to make an argument for standing that Aaron Spencer can't challenge an order based on the rights of others. And as a general matter, you can't do that. However, the issues raised in this extraordinary, it requires to consider the restrictions not directly towards Spencer personally. And we decline to uphold any part of the order in light of the order's clear lack of an evidentiary basis as a whole. The order is extremely broad as the person is restrained from speaking. It restrains the parties, their attorneys, any public official now holding office, along with their staff. How the fuck does that work? Does that mean like the county engineer can't talk about it? He has no fucking say in the case. Witnesses, court staff, and the defendant's family. The order is also extremely restrictive as to what information is shielded from public view. It restricts filings and perhaps courtroom proceedings from public view. The order implicates Spencer's right to a public trial as well as the public's right to know how its officials are conducting these proceedings. The state points out that Spencer raises arguments relating the gag order's application to officials and his family, um, and the restrictions on public and press access to the court file. And all of this occurred without notice. They say, however, Spencer clearly is standing to bring this petition requesting the court vacate the gag order in the criminal case because it's his case. It's pretty obvious. And they talk about free speech, and yes, free speech is also in Article 2, Section 6 of the Arkansas Constitution. And it's the free communication of thoughts and opinions is one of the invaluable rights of man. And all persons may freely relate and publish their sentiments on all subjects. The gag order is defined as the judge directing everybody to refrain from discussing the facts of a case. Thus, a gag order is a prior restraint. And prior restraints are the most serious and least tolerable infringement on First Amendment rights. And such a prior restraint on speech bears a heavy presumption against validity. And the Supreme Court has said it recognized that criticisms of the state lie at the very center of the First Amendment. Meaning, why are we prosecuting this man for killing a pedophile who was abducting his child? And notice they point out it would be difficult to single out any aspect of government of higher concern and importance than the manner in which criminal trials are conducted. Now, they say the Supreme Court has only addressed the issues of gag orders as they apply to the press, nor has the Supreme Court done a standard where such restraints would be permissible. So they say pretrial publicity, even if pervasive and concentrated, cannot be regarded as leading automatically and in every kind of case to an unfair trial. So they go through all this and they bring up that ultimately the Supreme Court has also held that the speech of lawyers representing clients may be regulated under a less demanding standard than the established regulation of the press. But still, there's no answer to the question of when gag orders are placed on everybody else. It says here the gag order intends to address the need to protect the jury pool and ensure all parties get a fair trial. Well, they point out the trial court has a difficult job of balancing constitutional interest. And they talk about the Supreme Court has made this clear when it granted habeas leave to a petitioner who had been deprived of fair trial in a state because of the trial judge's failure to protect him from massive, pervasive, and prejudicial publicity from the carnival atmosphere at the trial itself. And that's the Shepard case. And they point out that Shepard was an extreme case in which there was no doubt the deluge of publicity reached at least some of the jury. And the court concluded because he had not received a fair trial, they reversed his conviction. And while the publicity can prejudice a trial, an impartial jury need not be wholly unaware of information, including prejudicial information outside the record. Nobody's like, you're never going to find a jury who doesn't 100% not know nothing. So, and that's a fair argument to make. Look, well, everything's going to be there. No, even Karen Reed. These people knew about it. And so here we go. Sorry, I'm taking some of your guys' chat here. Half Irish says the Give Send Go is supporting the Spencer family. Yes, they do have a Give Send Go, but I did not have a chance to look at it, see which is the correct one here. Where is, hold on, did I miss something? I thought, so anyways, we're going to keep going here. We're going to keep going, Chad. So you know what? Turn to the arguments which should apply in this case. Well, to justify the prior restraint, there must be a factual showing of necessity. You have to show a necessity. And we need to get down to just how they talk about here. And they say determining which standard to apply, we must initially recognize whose speech is being restricted. We can identify three categories of persons subject to the orders: the attorneys, the non-attorney trial participants, such as the criminal defendants, witnesses, and court staff, and three, the public at large, those who are not in the trial. And they point out we don't address public or press gag orders because the order before us does not impose restrictions on the press, nor does any member of the press challenge it. We note this court has previously addressed gag orders placing prohibitions on the press, though. Once again, this is also a way of them warning the judge, don't be a dumb cunt. But they point out that, yes, extrajudicial statements of attorneys may be subject to prior restraint by a trial court. Notice, like Karen Reed, Yannetti and Jackson and Alessi and Eliza Little, they weren't allowed to talk. And that's okay. Attorneys aren't allowed to, but Karen Reed could talk. She talk. And they say because the gag order included all members of all three categories, they had to review each. And they say first we do the attorney speech. An attorney's speech is subject to greater regulation than everybody else's. We are limited to things. Attorneys have access to public, non-public information and are viewed as authoritative, both of which pose fairness to the trial. We're also officers of the court. And for the same reasons, we find it appropriate to allow greater regulation of attorney speech. And they decide that attorneys in Arkansas may be restrained from extrajudicial speech. Outside of court, you're going to be stuck. And this is also consistent with Rule 3.6 of the Arkansas Rules of Professional Conduct regarding trial publicity. And they say, next we consider the free speech rights of the non-attorney trial participants. And they say, they're not subject to the same rules as attorneys, but their speech has the great potential of great impact on the non-trial participants. You have a greater impact. So they're allowed to be restricted. The protections for non-attorney trial participants are greater than those of attorneys of record, but less than those of the public at large. Therefore, the speech may be restrained only to the extent it poses a serious and imminent threat of material prejudice to an ongoing proceeding. And he says, finally, we're addressing the restraints on the public. And restraining the speech of the public raises obvious issues regarding the lack of due process. And this is where you need to understand, this is them talking shit to Barbara Elmore. This is them saying, honey, what did you do here? We cannot fathom why the circuit court believed it could prohibit the speech of any public official now holding office. In fact, it is difficult to foresee any circumstance in which a prior restraint on the speech of the member of the public would include a public official could be constitutional. So having established the legal standards, we turn to the findings the circuit court must make in every case to justify the entry of a gag order. First, the court must determine whether the alternative measures would protect the rights to a fair trial. Here, Aaron Spencer says we could voir dire the jurors, use an expanded jury pool, give instructions, changing venue, or postponing the trial or alternatives. But the circuit court heard no evidence and made no findings. In addition, the circuit court must find that gag order would be likely to accomplish the goal of preventing prejudice. Again, there was no such finding. And then finally, a gag order must be narrowly tailored to prohibit only what is necessary to protect the integrity of the proceedings. In other words, the restrictions imposed must not be overly broad. And here they were overly broad. For example, prohibiting the public expression of an opinion as to the weight, value, or effect of any evidence, establishing the guilt or innocence of the defendant by any public official is clearly overbroad. And they say in some, the circuit court must find that the speech would pose a threat, that there are no other alternatives, the prohibitions will be likely to prevent prejudice, And the prohibitions are narrowly tailored. And that didn't happen here. Aaron also argued under due process that it was vague and overbroad. And it's impermissibly vague, and it's impossible to know what is covered by some of the provisions. Are statements on social media restricted or must be removed? Whether previously public filings now removed from public access may be shared. For what for public dissemination means. And precisely who this gag order restrains. It's not clear. It's not clear. And the void for vagueness doctrine addresses these discrete due process concerns. You have to know what is required of you. People should know what is required of them. And, you have to know what you're doing. You have to know what's going on there. And this says you must also, it's based in part on the need to eliminate the impermissible risk of discriminatory enforcement. Vague prohibitions create a chilling effect because nobody knows what speech is protected. They say, here we agree the gag order is unconstitutionally vague and must be vacated. Who is included as part of the family? Does the order purport to restrain the speech of his second cousin? Or only that of his parents, spouse, and children? Due process requires much more specificity. It does. It does. Because let's say it's his cousin and his cousin lives, I'm his cousin. And I say Judge Barbara Elmore in Lonoke County in the 23rd Judicial District in the 1st Division is a flaming cunt whore of a jurist. And this case is bullshit. Am I now held in contempt? How does that work? How does that work? It's not clear how that works. It's not clear at all. It's not clear at all. So in his writ, Spencer does not develop his due process argument, but in briefing, he clarifies that the circuit court exceeded its jurisdiction. And it's unnecessary to address the overbreath because it's void for vagueness. And sealing. This is one where they say, finally, we address the sealing of the case. Spencer contends the community has a right to know what the government does. And he cites that the sittings of every court shall be public, and every person may freely attend the sittings of every court. And it says, this court has long recognized that an accused may assert his right to a public trial by arguing the exclusion of the news media, and the public violates that right. Very true, chat. Very freaking true. And then real quick, Unhung Hero for 10 subs. Let's go, chat. Freaking thank you for the support tonight. Getting a woo going. That is what you guys deserve tonight. That's what you guys get is a woo. Get 2 woos for that tonight. You get 2 woos. And today Clyde wooed a couple of times. It was kind of cool. He did a couple where he was like, ooh. And then he did a big woo. Thank you, Unhung Hero, for your support and your generosity. Yes. And it says here, after the court order was sealed, the filings were removed from public view. The inherent authority to seal parts of files is tempered by the requirements that a request to seal part of a file must be particularized. And that's true. It must be limited and narrowly tailored. There must be good cause for sealing part of a file, like a trade secret, or special information, and it should be in effect only as long as necessary to protect the interest. And it says not only are the written records inaccessible to the public, but also the briefs and statements from counsel and oral argument indicate the circuit court's courtroom was partially closed during Spencer's arraignment. Although it appears the circuit court intends to close further proceedings of the public, we caution the court from doing so without an evidentiary basis and adherence to the required analysis set forth in Waller v. Georgia. That's their way of saying, bitch, mind yourself. That's their way of saying, bitch. You best check yourself, honey. You best check yourself, Barbara Elmore. And they say, as we stated above, the right to a public trial is one of the most important safeguards. The prosecution of persons accused of crime, yes. And it says conclusion. The gag order is far too broad and restrictive. It's also impermissibly vague. The order was entered without requisite findings and wholly without a factual basis. Therefore, it is a plain, manifest, clear, and gross abuse of discretion for which there is no adequate remedy. They say, by this ruling, we don't foreclose the possibility the circuit court may issue a subsequent gag order that's narrowly tailored. He says, we emphasize, though, a gag order should be a last resort, not a first impulse. The entire Supreme Court went along with this. The entire Supreme Court of Arkansas was like, why the fuck did we do this here? Why did we do this? They all concurred. They all concurred, chat. They're like, what the fuck? What the fuck? And I love this from the last part here. And this is from Justice Brawny or Brony. I don't know, Brony. It's a very Italian name for Arkansas. And he says the repeated attempts to veil these proceedings as secrecy can only breed ignorance and distrust of the courts and suspicion concerning the competence and impartiality of the entire criminal justice system. He says remedying that danger warrants strong medicine, and I'd apply it. So, this is just not acceptable. And it's interesting. And this is the other thing here. Context suggests why there was this gag order. The same circuit court that issued the gag order also granted Michael Fosler's release on bail. It's that decision, what the defendant's lawyers called the decision to release a predator, who repeatedly violated the defendant's child on a low bond, that set off the chain of events that led to the fatal confrontation that's the subject of the case. And it's that criticism the state claimed and the circuit court effectively concluded justified gagging everybody. And they say this sequence raises serious concerns. If openness enhances the appearance of fairness, so essential to public confidence, then secrecy has the opposite. It erodes trust. Boom! Boom, boom, boom. Yes, and Judge Elmore had to suffer. She was forced to deal with it. She was forced to deal with it. And now we'll see what she does. We'll see what she does. But that is Aaron Spencer's case right now. As far as things are set right now, chat, we have the next case updates are here they are, and this is the actual case update right now as far as the case is set to go. By order of this continuance, so Michael Kaiser and of Lassiter and Casanelli. So again, it's a very Italian name for Arkansas. And Chief Deputy Prosecuting Attorney John Cuckins, on behalf of the state, did a joint motion to continue. The pretrial hearings are set for August 8th at 9 a.m. The jury trial is set for September 22nd to September 26th at 9 a.m. I don't know how the hell anybody's going to be ready to try this at this point. But there you go. Yes, the Lonoke County government is forced to cope. They're born to seethe. Now, this was the last thing that was dated from March 3rd. So that's the last thing we have. Because when you go back to the rest of this, guys, there isn't really a lot going on. There's some kind of like stuff has been stayed, and the court, like everything got stayed while the Supreme Court was dealing with it. So we don't know what's going to go on there. We don't know. I don't think any of it's going to happen at this point. Oh, you guys are Japan earthquake. That's not good. Everybody be safe. Let's see here. Whiskey 77 for $10. Thank you. Whiskey says, even ag biochemist is better at not gagging than this judge. So I've heard. Jefferson C. Post says, this sounds like a fuck ton of prior restraint. It is. It is, guys. Almond Brown member for 19 months. Thank you for being here. Thanks for the support. Says, who is Aaron Spencer? Well, I think we answered that question. Jefferson Post has been a member for 11 months. Thank you for the support, man. It's saying, trust the government to ruin a feel-good story. Yeah. Eric Fulm says that, did Aaron Spencer Cain Velasquez this guy? No, unlike Cain Velasquez, Aaron killed the right target. Cain couldn't shoot the right target. Danielle says, is that kidnapping? I would argue yes. Fosler kidnapped Aaron's daughter. Luke, you said, don't forget the non-public arraignment. I think we got that. Poffin says, well, what about vigilante justice? Well, here's the issue. Yes, vigilante justice is something we should not want to encourage in our society. People get it wrong. We want justice to be impartial and dealt out effectively. This guy watched his daughter get picked up by a pedophile, though. He is allowed to chase that man down and stop the bad man. Like, it's no different than watching her get abducted from a playground and then he chased down the pedophile and beat him to death. This is no different. This isn't him, the daughter coming to him saying, hey, daddy, this guy touched me. And then Aaron goes out and hunts him down. That's vigilante justice. This is a man protecting his children. Haystack is saying temporary insanity. No. No, I mean, you could argue that like he was massive emotional distress. My daughter's being kidnapped by a fucking pedophile. My daughter's missing. I have to find her. But no, this is self-defense. It's the defense of others. I don't know how you're going to find a jury in Arkansas that's not going to say, we find the defendant not guilty and based, and we sentence him to a steak dinner on our treat. I don't know how that doesn't happen here. I don't know how a jury convicts this man. Really, I don't. Sweet Tooth Fairy says, do you think she did the gag order to shield her from the consequences of giving bond to the pedo? 100% I do. 100% I do. Poffin saying, isn't there a PDF database? Yes, but you're not in the pedophile database until you're convicted. So this guy hadn't been convicted yet. Sorry if it's your kid, you're allowed extra shots. I mean, like I said, man, homie put in work. You know what? Like, he shot the guy, he mag dumped into him and started beating him. Oh, well. Being a pedophile is a dangerous business. Let's see here. Poffin saying, shouldn't it go out of state because of the conflict of interest? Well, you can't go out of state. You have to try it somewhere in Arkansas. You could maybe change venue. But no, like a different prosecutor's office could prosecute it. But that's a very good question. Thank you for asking. Now, there is an interesting thing that was filed in this case, and I saw this, and I was like, it's a motion in limine, chat. And this is a motion. Remember, motions in limine are motions to exclude things. And this is interesting. It's interesting here because this is the defense asking to exclude evidence. And it's interesting evidence. What did they find? What's being done here? Motion limiting to exclude reference to an alleged glass smoking device. Uh-oh. Uh-oh, what is this all about? Let's see here. Shouldn't this judge recuse herself? I'd argue she probably should at this point. She's not going to give anybody a fair shake. She's already demonstrated she's compromised. So here we go. The state's discovery file, meaning the prosecutor's discovery that's been provided, alleges officers found a glass smoking device in the patrol cruiser where they were detaining Aaron Spencer at the scene of the night of the charged act. Spencer demanded a blood test to confirm he was not a drug user. The prosecutors did not file any charges related to the device. Now, here's the deal with this. Even if it's pot, meth, or crack, if you were intoxicated, you don't lose the right to self-defense. And nobody's arguing. The state is not like, is the state going to argue that the child wasn't in the car? Are they arguing that he used, like, this guy had surrendered? I mean, maybe that's how they're getting the murder, but him just killing him as soon as he attacked him and stopped him, no jury's going to fucking care. I don't care if he was sparking up fucking meth right before he hopped in his car and grabbed his pistol. I don't care. I don't care if he fired up a big old fucking shard of crystal meth. I really don't care. I don't care if he fired up a big old crack rock. He's allowed to defend himself and his daughter. So they didn't search him before putting him in the cruiser. Yeah, I mean, I don't know. Did they check to make sure it wasn't in there? We don't really know. Did he take a blood test? I don't know. I don't know if he did. But remember, that stuff is going to be out of your system very quickly. And they say the evidence has no independent relevance. And yeah, it's not relevant to whether or not he committed this crime. If they wanted to argue he was intoxicated, they haven't done anything to show he was intoxicated. They could have got a blood draw or something like that. So it was planted by the cops. It could be. Who knows? It doesn't follow to any of the listed known exceptions to the 404B, which is the prior bad acts evidence. Further, any probative value, which is to make it, is it more likely or less likely this crime was committed, was grossly outweighed by the dangers of unfair prejudice and confusion of the issues. Yeah. It doesn't make it any more likely or less likely that Aaron Spencer committed a murder. And here's the point. Rule 404B of the Arkansas Rules of Evidence says, the evidence of crimes, wrongs, or acts is not admissible to prove the character of a person in order to show he acted in conformity therewith. It's called propensity evidence. Well, he's a bad guy and a murderer because, look, he's got meth on him or crack on him. But you can show prior bad acts to show proof of motive, opportunity, intent, preparation, planning, knowledge, identity, or absence of mistake. So why can you show absence of mistake? Let's say you steal cars. You could say, "Oh, I'm a repo man. I thought this was my car to pick up." You might get away with that once, but if every time they catch you, you're always making mistakes, that's clearly a pattern, and they can use that against you. And the prior bad acts must be independently relevant to the main issue, chat. And remember, all evidence is relevant to some point. It's always got relevancy. But how much relevancy does it have? And then from there, what's the probative value of that evidence? So all evidence is relevant in some form. And just how relevant is it? But the bigger issue is what's the probative value of that evidence? Is it going to help you determine whether he committed this murder or didn't commit this murder? And that's where you get to the probative value. And then when you determine there's probative value, you then have to now move on to the next step of probative value versus prejudicial effect. And you have to weigh that one now. Eric says they could have given him a fake hair test. Yeah. And they say, Even if relevant under Rule 404B, evidence can still be excluded if its probative value is outweighed by the danger of unfair prejudice, confusion, or misleading the jury. Mhm. And the evidence at issue has no independent relevance to the charge act. Whether he possessed a glass smoking device, something that he disputes, has no bearing on whether he knowingly killed the victim or whether he's justified. The evidence is irrelevant. They say instead, this evidence is the worst kind of propensity evidence, meant to encourage the jury to find Spencer guilty, in accordance with his purported character as a drug user, despite no proof of this in this case. So they say the trial will become about whether Spencer is a drug user rather than he committed the murder of a pedophile who was abducting his daughter. So, and they point out the danger of unfair prejudice from omission of drug-related evidence is great because a drug offense is the kind of crime a jury may feel the defendant should be punished for, regardless of his guilt for other crimes. Yeah, drug offenses are really bad. They think that people don't like druggies. They don't want to help druggies out. So therefore, they want the court to exclude the evidence at its entirety. So that is what happened there. And then it's let's see here. Where is... So there's ultimately there's a secondary and there's a supplemental motion that was filed, and that's providing new information. And this gives us a little bit more here, you guys. And this was filed in June. And this is a bit interesting here, okay? So this is, once again, it's a supplement to it. So they say the smoking device at issue was found in a patrol car at the scene of the shooting. Reports detail the events as they relate to the finding of the device. At the scene, an officer placed Spencer in a patrol car, removed him, and then later placed him in the back and the other side of the patrol cruiser. When Spencer was placed in the vehicle, he noticed the device and immediately notified. Here's the interesting thing. He noticed the device and immediately notified the officers already inside the cruiser. Sounds like it's on body cam. Spencer immediately denied it belonged to him and demanded a drug screen. He consented to a blood draw, although if the state ordered a test, the results have not yet been disclosed, which would be Brady material. In addition, the testing of the device yielded a partial male DNA profile that affirmatively excluded Spencer. And they say, based on the information provided by the state, the evidence lacks sufficient connection between the device located in the car and the defendant. So therefore, they want the court to exclude this evidence at issue. That's very interesting. They found someone else's crack pipe in the car. Not really uncommon to have that happen. Not really uncommon to have that happen, chat. So. But as far as any response from the state yet, there is no response to anything. So. There's not been a ruling on this yet, but I kind of get the feeling she's going to do whatever she wants to do. So, and then, yes, they want it all done. Yeah, planting evidence, or they just never cleaned it up. It's more likely they didn't clean up the car. Yes, they found Hunter Biden's pipe in the car. Well, he was in Arkansas banging those hookers. Bob, the Defense Diaries podcast, Bob Mata, guys, he just got done having an interview with Bob Alessi from the Karen Reed trial last night. Yes, the glass pipe, as I said, is bullshit. Yes. And Bob, I'm going to reach out to you, man. We need to get together here. Come on over. We need to hang out now that we're done with Karen Reed. Let's see here. The glass pipe is bullshit. I agree. But more importantly, Bob, at the end of the day, even if it was his, it doesn't alleviate his ability to protect other people. Intoxicated people still have a right to self-defense. And by that, they have a defense to others. So it doesn't really do anything here. And yes, Chief Deputy Prosecuting Attorney John Cuckins is very desperate to introduce things at trial. But that is where we are. And guys, if you haven't, go check out Bob and his wife, Allison, over at the Defense Diaries podcast. They do great stuff over there. Yeah. Oh, Alessi's tomorrow. Oh, I thought it was last night. Okay. Sorry, chat. Bob Alessi is going to be tomorrow night. You guys are talking about the earthquake there. Never mind. Eric Rodriguez saying, would the pipe have DNA on it? Sometimes. Remember, chat, we talked about this before. You can leave DNA on different things. Yes, ideally something you put in your mouth and you're smoking, like a crack pipe or a meth pipe, you probably will leave DNA on because it's your saliva. But remember, just, but who knows why the DNA came from? Remember, I can touch this mug. And you might not be able to find fingerprints there. You might not be able to find DNA. Sometimes I'll touch it or maybe go like that, and you'll find all sorts of DNA and shit on it. It all depends. Touch DNA, fingerprints. There's so many variables. I've had guys who, I've mentioned this before, they've been in a shooting and they're on video, they're throwing copper, like they are laying down hate, and they're on video and they clearly have that gun in their hands. The police find the gun, like the dude throws it down right away. It's a nice night out. The police find it immediately. No one's touched it. No DNA, no fingerprints. And it's not like the guy sat there and like wiped it down and threw it down. No, he just boom, 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 and dropped it and ran. Sometimes you don't leave DNA. Sometimes you don't leave fingerprints. That is great, though. It's there. And it's interesting that, that's a big thing too, Chad. If you're ever put in the back of a police car, don't be afraid to check and say, I want to see what's in the back. Because, if you're in there with it, they're going to try to pin that on you. But that's why police are supposed to check their cars after they arrest people, because people can leave things in the car. So, wasn't there a body cam video not too long ago of a cop ODing on fentanyl in a bathroom? Yeah. But the idea of cops doing drugs isn't uncommon. I mean, although if the cop's doing drugs, I doubt his crack pipe made it to the back seat. But the idea of cop arrested a guy in rural Arkansas smoking crack or smoking meth is probably very high. So, can Aaron insist on testing at Prince DNA test Aaron? Well, they already said it's been determined that it's not his DNA. So, Sarah Brown saying Bob and Allie have done great work on the Spencer case too. He had the same energy, the same kind of energy I felt about the case. The state has a right to a fair trial. Yeah, they're not entitled to it. If you can't convince a jury to convict people, well, maybe you shouldn't be convicting. Like, I really want to sit this prosecutor down. Like, was this pedophile guy your buddy? Did you guys diddle kids together or something? Is this like, pedophile, pedophile blood oath? Because the prosecutor for Lonoke County sounds like a pedophile. He's running a lot of interference for a fucking pedophile right now. He's running a lot of interference for a pedophile. I mean, these guys, like this office, mate, I see an office full of pedophile protectors. You know who we are. I see a whole group of people who are running cover for pedophiles. A whole group. I'm sorry. Even the underlings, the office manager, y'all involved in helping a pedophile. Like all of you. Sorry. Your boss is enabling pedophiles. I don't feel bad for you guys. So, I leave mayonnaise residue behind, yeah. They pulled male DNA out the pipe. Spencer was excluded. I agree, and it makes it even easier. So, So the arrestee's car, the police car, the police car, the police car had it. So yes, yes. This guy probably is a chomo. The prosecutor himself is probably a chomo. He's a chomo. Although, to be fair, Michael Fosler, he's a chomo. Yeah, the hot check coordinator. I don't even know what the hell that is. That just like, we write checks and they're hot. Ooh-wee. What are hot checks? Like the, okay. So they have that big a problem. They have a person who's specifically there for the forgery issues and the stolen checks. Really? That just sounds like a fucking make work job. Like they have a coordinator for all the stolen checks in Lonoke County. Like we needed to hire a person for that. Come on now. Come on now. So yes, hot young checks. Do we know anything about the attorneys, the defense attorneys? They seem pretty confident to me. They've been fighting tooth and nail for their guys, so I think they're doing a great job. I think they're doing a great job. So I have no reason to talk crap about them. I have no reason to talk crap about them. So no, I think his attorneys seem to be doing phenomenal so far. The defendants seem pretty based. Yeah. They immediately banged on that drum of it's not their right to a fair trial. Although once again, we've got remember chat, just like we learned with Judge Bev, a retarded judge can ruin you. An awful judge can ruin your case. An awful judge can ruin your case. You can have all the facts in the world and all the case law in the world on your side, and you get some moron on the bench. Remember, chat, we got that bell curve going. We got that bell curve. We got the distribution. Here's the median. And here's where most people fall in between. They fall in between here, and then you have the really good ones who are really good, and then you have the ones over here who are really bad. And if your judge is over in this end of the spectrum, you're in trouble. They're going to suck, and there's going to be judges who are in this end. There's going to be judges down here. You might be unlucky enough to get that judge right there. A bad judge will ruin you. A bad judge will ruin you. Oh, yeah, we went through her getting beat. She got BTFO'd, Bob. She got BTFO'd. Completely. This woman got BTFO'd. Blown the fuck out by the Supreme Court of Arkansas. And it's funny because they had to explain to her, where are you guys using this form? Don't use it anymore. Bob is saying Aaron Casanelli, once again, is such a very, like I said, there's not a lot of Italians in Arkansas, is a pit bull out of Little Rock. Good. May they rain hellfire down on the prosecutor's office. May they rain hellfire down on Judge Elmore. And if you're going to come after me for that being a threat, I guess you do what you got to do out there. Give me a gag order, Judge. So, you missed some of the best. Read the entirety of the bottom concurrence. Let me see here. I'll take a look at it real quick. What did I miss here? Let me see here. Yeah, I'll take a. So, But yeah, no, we went through a lot of this guy's thing here. Although, yeah, this is actually very interesting. Well, this is actually kind of interesting here. I didn't see this part. I hadn't read it. I think I must have read it. I think I remember reading it. So they point out that this is once again Justice Broney or Bronny. I'm sure he's like, if he's got kids and the kids are like, no, we're not Bronies. They say that, the biggest issue is the gag order itself. On its face, targets a broad swath of people. Things there. And they say worse, the order itself was sealed, raising concerns about selective enforcement. And that's the worst part of all. The gag order itself is sealed. So how do you know how to it's a secret law. You don't get to know. It's like filing your taxes. Well, how do I know if I didn't pay enough? We'll pay enough and we'll tell you. Well, I could talk about the case. Well, talk about it and I'll tell you when you violated the order. It doesn't explain why the extreme remedy is warranted. Instead, it declared it would help ensure the fair trial. They say, on the contrary, they point out that this is actually the interesting thing here. On the contrary, the circuit court entered that order just 6 minutes after the clerk docketed the defendant's 19-page opposition to the state's motion, or barely enough time to make a pot of coffee. That approach cannot be squared. Like, we're going to have to go back and see that, but wow, they didn't even get a chance to respond, and the judge had already made up her mind. More scumbaggery by Judge Elmore. I mean, they should be moving for a recusal at this point, I think. That's, get a different judge in there who's not a complete tard. That approach cannot be squared with the First Amendment, and it underscores the gag order wasn't a last resort, but an impulse that was unconstitutional. And once again, chat, I will tell you, had this happened in Ohio, for example, I doubt you find a grand jury that would indict. And you know what that means? Aaron Spencer would never face criminal charges at a felony level. He could be charged with misdemeanor offenses, but he would never be indicted for a felony. He can never be charged with murder if the grand jury refused to indict him. So it's, once again, there are states that this is good for, but this is very common in a lot of states. Prosecutor can go file an information. That's what happened to Kyle Rittenhouse. Kyle Rittenhouse was never indicted. They filed an information, and they shouldn't be allowed to do that. They should have to secure an indictment from the grand jury. Oh, well, that's a lot of work. I don't fucking care. You need to go in there and stand up in front of a grand jury and say, we want you to charge this man for murdering the pedophile who abducted his daughter. The prosecutor needs to go in there and do that and look them straight in the eye. I don't care that he doesn't want to get laughed at. That's his problem. Yeah, they went by way of information, which they should not be allowed to do. And that's why I thank God I live in Ohio. Because if this happened in Ohio, this never would have happened. I don't see any grand jury in Ohio indicting this guy. So, yeah. The very pedo that had raped his daughter. Yep. Yes, it's a very bad judge. And this is going to be even worse than Bev. Because, I mean, once again, she's going to think she's smart. And remember, she's on that curve. And she's on that distribution. And she's not a smart judge. I don't have faith in this woman anymore. I've only watched her once or twice. Kitchen Knife Rescue says, with the crack pipe in the back of the squad car, open up the body cam from earlier in the day leading up to the attainment of Aaron for discovery. Yeah, because like all that, like who did you have in the car beforehand? I'm sure that's already been asked for in discovery. What was the guy's last arrest? Who was in the car last? And it's probably somebody who got charged with drug stuff. Where Tiger Ray is saying, is this where Judge Chupp is? No. Everybody likes to make fun of Judge Chupp for the Vic Mignogna case. You know, the Vic Mignogna's attorneys fucked that case up. Judge Chupp did the best he could with a shitty case. So I know everybody likes to make fun of him, but it's not his fault. It's not his fault. So, yep, not guilty, Team Woodchipper. I know. The jury's going to say, we find the defendant not guilty and very based. And I really hope they say at the end, we're going to take you to a steak dinner, sir. And then they all clap. Because that's what's going to happen. I don't see how any jury's going to want to fire this. Bob says, I'm thrilled you're with me on that. You're on this with me. Oh, this is like, I mean, what am I like? What are we gonna like? This is the most clear-cut case of defense of others you could imagine. Your child has been abducted by a violent predator, and you catch up to him, and he's combative. Remember, chat, kidnapping is a violent felony. It's inherently violent. Rape is an inherently violent felony. Guess what Aaron did, man? He put on his boots and he picked up his chute. Like a real paratroop, man. He fucking geared up. I mean, he grabbed his pistol and hopped in a car. But, he was all about that. Homie geared up. Homie tooled up. And, I mean, the only thing he's missing at this point is if he came out with a switch.
Switchy. No talk. No cap. No talk.
That's the only thing he's missing at this point is he'd come out without a switchy. And just to that guy. But I mean, I'm sure that Fosler wasn't just agreeing to not fight. I'm sure he tried to fight. I'm sure he tried to get lippy. And you know what? I'm sure dad fucking air conditioned him. And center punched him, whatever you want to call it. Center punched him, punched his ticket. Whatever you want to say. Whatever you want to say happened. I feel no loss for Michael Fosler, the pedophile. I have no loss for this man. I hope he's burning in fucking hell. And I hope it's hot down there. I hope it's hot. And then Kat, but not Kat Williams, for 5 subs. Kat, it's good to see you guys. Oh, there's more in that concurrent saying they should boot her off. Where's that? Hold on here. We'll take a look at that. Hold on. Let me see here. I'm going to take a look for this real quick. But Kat, thank you for your support, your generosity. Guys, you can find Kat over on her channel covering things. She does great stuff that's out there. She does an awesome, awesome job out there, guys. She is great to follow. Great to follow. Let's see here. Let me see here. Okay, hold on, chat. We're gonna get into this now. You're saying there's a spot in this where they talk about it. Let's see here. Okay, well, I don't see where you... Where do you see that, Luke? I don't see it. Let me see. I don't... I don't see where you're talking about this because I must have missed it, but I don't see it, man. You're saying it happened somewhere here. Let me go get it real quick. Yeah, tell me which page because I didn't see it. I'm astounded, dumbfounded, and flabbergasted. Yeah, the PDF was a cop. He was a former cop. He was like a former police chief, which, yeah. Just covered a self-defense case that might have a fighting chance if the defense attorney wasn't a noob. Which case is that, Kat? I'll have to take a look at that. Yes, Kat is awesome. Kat is very much awesome. Diddy's trying to get a $50 million bond. Diddy's probably going to get time served, you guys. He's going to get a very light sentence. Remember, the judge has already said, like, what do we normally do for people in his position? And he's probably going to get away with, he's probably going to get that. Haschick has been a member for 9 months. Says, thanks for covering this. Pedophiles getting dirt napped is never a bad day. That's always fun. I'd be happy to cover it. So thank you for being here, Haschick. And Haschick gifting 10 subs. That gets you guys another awoo tonight. That's right, another awoo, chat. Every time you give subs, Clyde gives you an awoo because he's such a good boy. Let's see here. Sweet Tooth Fairy says, shouldn't the judge recuse herself? I think so. Half Irish saying it's a prime example of jury nullification. Oh, 100%. 100%. I think there should be jury nullification. KLF saying it's a 5-hour trial. Okay. You're saying page 26, bottom of the first, bottom of the bottom concurrence. Okay. Yeah, hold on here. Oh, okay. Hold on. Here we go. Okay. Yeah, here we go. He says, we cannot allow this pattern to continue. He says, I'd invoke this court superintending authority to reassign this matter to a new circuit court judge. Wow. You've fucked up really bad. You have fucked up really bad. You have fucked up very, very badly when they're saying you don't deserve to have this case. Yeah, I know they won't need jury nullification, Bob, but the jury could just say we don't care. Yes, the defense of other statutes on all fours, 100%, chat. And the defense of others is part of self-defense. If you can defend yourself, you have the right to step into that person's shoes and defend them. And what better person can you do that for than your children? A parent has every right to defend and protect their children. So the idea that there's no self-defense for dad is preposterous. He has every right to protect his child from a violent sexual predator. So, yes, the Supreme Court just said they want to remove this. They want to remove her because she was so ridiculous in her ruling. And I don't think that's a problem. Is she a bad judge because she ignores the law in favor of her political views? Is that what typically divides a good judge from a bad one? No, it's not the politics. It's just judges who make uninformed decisions. They make ignorant decisions. They make a bad decision. They won't fix it. And they make decisions that are completely anathema to any basic legal principle. Like this one here. No one can talk about the case. No one, no way, no how. How do you make that order work? Because once again, who can talk about it? If I'm Aaron Spencer's cousin and I'm in Ohio, I'm going to talk about the case. Am I going to get held in contempt? Is she going to hold Aaron in contempt and revoke his bond? I mean, what's the issue here? What's the issue here? It's just she's an ignorant judge. I'm sure she's done all kinds of retarded things before and nobody's been able to stop her. But that's the issue, that she thinks she's powerful. I'm the judge in Lonoke County, Arkansas. Like she thinks that means something outside of her courtroom. So, is she going to hold us in contempt? I mean, if we had known about this case, I would have intentionally dared her to hold me in contempt. I would have dared her to try to gag me. That would have been so much fun. But this judge, Judge Elmore, is afraid of being held accountable. She gave a pedophile a dirt cheap bond. And, you know, we can make the argument people are entitled to bond. Okay, reasonable bond. But she won't stand up and accept that she's responsible for that. And had she not granted bond, this guy wouldn't have died. She needs to be held responsible for that. She needs to answer that to the community. And she was refusing to because she's a coward. But I'm sure this is not going to be the first shitty legal decision she issues. Notice, in the case for Aaron, that's really the only legal decision we have. We don't know any other legal decisions in this case. There's no orders. So I'm sure she's going to issue all kinds of Bev Canoni garbage. It's going to be garbage tier going forward. Yeah. That needs to be a soundbite. I don't know which part. Oh. She probably thinks she's Judge Judy. I don't know, but I think she thinks she's a lot smarter than she is. So, this judge is absolutely disgusting. This woman should not be in charge of this. And the fact that she has presided over trials where people may have gone to prison is scary and terrifying. Absolutely terrifying. So, she thought she could just cover it up. Yeah. And thankfully, there are good attorneys there. Has she put anyone to death? I don't know. I don't know. But let's see. Lono County, Arkansas. How big is this county? It's a pretty big sized county. It's right outside of Little Rock. It is 74,000 people, which making it the 10th most populous out of Arkansas, 75 counties. So if you guys don't know where we're looking at here, this is when you have the great state of Arkansas. Remember, chat, for some reason, Arkansas does not touch Kansas. For some reason, Arkansas and Kansas do not touch, and I don't understand why. But anyways, here's the state of Arkansas, capital Little Rock. Here you go. There's Little Rock. And then right next to it is Lonoke County. And then here is Cabot. Here is the county seat where the courthouse and everything is. So that's a big freaking county, though. I will say, holy cow. That is a lot of lands. That's a lot of land mass. So Judge Judy would have walked himself out of court. Yes. It's where all the Democrats live since Bill Clinton was governor. Ah. Yeah, she slept with the Clintons, probably. She helped them smuggle cocaine. Yep, Cabot is the biggest city in the county. Yep, the county seat. Your sister-in-law lives there, allegedly. Yes. If I was on the jury, there's no way I'd vote guilty. I know, Henrik. Myself included. And I don't know how they're going to find a jury. The state's crying about finding an impartial jury. I mean, you're going to... I don't know how you can find an impartial jury when a man acts righteously. You're not going to. And that's the hint. They should drop this. But in the meantime, they're dragging him and his family through hell. Remember, even though Aaron knows that he's righteous in this, he has to sit there every day. And I know this is something I'm sure if you were able to sit down with Karen Reed, she knows she's going to win. And I've mentioned this to Bob before when we were sitting there doing the verdict watch. Every second Aaron Spencer gets free, it's going to be, you're facing life in prison. You're facing life in prison. You're facing life in prison. It's going to be there. It's nagging at you. Your sleep. And you wake up like, it's a great day. I'm under indictment. Fuck. For, life in prison. So, yeah, it's going to be tough. It's going to be tough. You're going to make a sandwich after all this talk. Was his bond set? Yes, he has a bond. He's out. He has a bond. He made his bond. So, he posted a surety bond. He got out many moons ago. He got out pretty much right away. And that wasn't an issue for him. Bama saying, wait, he doesn't have a bond? Does he have a bond? It doesn't say he's held. No, he's out. I'm pretty sure he's out. Hope his bond was a signature bond. No, he had to pay. He had to post a cash bond to get out. So, yes, my understanding he's free. Yes, there's no danger to the community. Bob says I'm taking off. All right, Bob, see ya. Guys, Bob and Allie over at the Defense Diaries podcast. Tomorrow night, the great Bob Alessi from the Kieran Reed trial and also of DLA Piper. Catnut Williams, been a member for 16 months. If we get you a Clyde plushie, can you put it on the Sean plushie shoulders? Chat, we're working on. Don't you worry about that. I appreciate the thought here, but we're working on stuff. Just let things percolate. Let things percolate. Polly Popcorn says Kieran Reed's having trouble getting her car returned. Yes, it's very true. The government is not returning her car or her cell phones, which is probably very likely because her car is ruined when they tore it apart. And they let Shannon Burgess go dig through the infotainment console. And he done wired up to his stuff because he's a college man. He's a college educated man. Yeah, all of her cell phones, yeah. So no, I mean that said though, if I'm Kieran Reed, I'd sell my car off and see if somebody wanted to buy it. I guarantee you people out there would buy it. She's got to have some person out there like that wants that macabre piece of history. You know, people own the Bonnie and Clyde car. Somebody can own the Kieran Reed car. Needs a new infotainment system and a new taillight. Other than that, it's in mint condition. Like she barely had any miles on it, so it's in really good. Yeah. So yeah, there we go. Yeah, they gave the car to Welcher. No, they did not. They had to come get the police. They had to come look at it with the police. EDW Raptor's been a member for 23 months. It says happy birthday, Sean. Well, thank you. It's not my birthday yet, though. So, but yeah, she's trying to get her shit back. So a big earthquake just hit the Pacific, and there's a tsunami warning for Hawaii, but the news isn't covering it. Interesting. Well, hopefully everybody's safe. They transported the car to Texas, I believe, for the chip on. Oh no, I thought Burgess came there for all that. I thought Burgess came all the way up here for all that crap to Massachusetts. An 8.7 earthquake off Kamchatka, not the Kamchatka Peninsula, chat. That's up in Russia. Dolly Talk's been a member for 17 months. Is it your birthday? No, August 10th is my birthday. But thank you for the support, Dolly. Hope you're doing well, man. And Cat Williams gifting 5 more subs. Let's fucking go, chat. Big support tonight. Yeah, I mean, yes, a new tail light and all that is only a couple $100. It all depends, though. If they damaged the chips and pulled everything out of the thing, like Karen's car might be fucked, depending on how bad they messed with it. It all depends on how bad it got messed with. Will Clyde stack sandwiches for your birthday? No. I'm going to see family. We I don't know if Clyde's going to come with us. He might, because I might go swimming. So I'll bring Clyde with me and see if Clyde will swim. But no, Clyde's going to be on. He'll be guest. He won't have to cook. So. Let's see here. The pedophile list is mandatory, right? It's not an opt-in. It all depends on how you're if your offenses classify under the Adam Walsh Act and what does work there or not work. I mean, it all depends. Some of them are qualifying offenses, some aren't. So there's a bunch of ways it could happen. Can they order Aperture to give her the blue paint car? No. No, because they bought that with their own money. So that would be a takings issue if the court ordered that. And rightly so, it'd be a takings issue under the Fifth Amendment. So. Oh, okay. So yeah, Ron and Tony, you guys are saying it could have been a marijuana glass pipe. Maybe. But if that was it, I don't know if they'd be really trying to tie him to like, oh, he smoked the demon. Well, actually, I could see the prosecutor saying he smoked the demon lettuce. I could see it. I could see that happening. So, will I cover this trial? 100 freaking %. Yes, I will. Are we gonna do a model stream later? In a little bit here, yeah, we probably will for like an hour or so, but I need to get to sleep. I didn't get really good sleep last night, so we'll probably do it here in a couple minutes, set it up, and then probably go for like an hour or so. The devil's lettuce, the hippie cabbage, it's all the same thing. Oh. It's Arkansas, of course they would. That makes sense. So, all right, chat. Well, that is it for tonight. Aaron Spencer, chat. Guys, go out, support him on Give, Send, Go. If you want to help someone out. But I mean, thank God he's got it pretty easy. This is a layup. Fucking pedophile abducted your kid and you have to fucking put him down. I mean, why are we even here? I shouldn't have to be talking about this case. I shouldn't have to talk about this case. But they're making us. Blanco Boy for $10 saying, are you aware of the upcoming Donald Day Jr. trial in connection for the Willoughby shootings? I don't know who that is. Let me see. What is this? So let me see. The Willoughby shooting. Is this one? What the heck is this? Hold on here. The Willoughby shooting. What the heck is this? Oh, it sounds like it's something in Australia. I don't know if we're going to be able to do anything. It sounds like it's in Australia. Yeah, they don't we're not allowed to, they won't show those, so. Yes, there's rule number 1, don't touch kids. Yes. Will you guys cover the camera guy suing AEW for John Moxley shoving him during a PPP? Yeah, send me the thing. I'll take a look at it. That'll be fun. Send it to me. Email it to me, chat. Email me this stuff. I'll be happy to look at it. A group of Aussies ended some police, and a group of Aussies ended some police and is a U.S. citizen being tried for inciting it from here. Wait, the Australians are trying him. He got extradited to Australia for causing Australians to kill cops? What? This is weird. So the cops got shot. Okay. Okay. Okay, let me see here, chat. Okay. Let me see here. So I don't see how this guy got Oh, well, he got charged with interstate threats. That's such bullshit. Threatening an FBI agent. Oh, well, that guy also got charged of being a felon in possession of illegal firearms too. So that is a little bit retarded there on his part. Sounds like he got caught. Also, is being tried under U.S. law. Yeah, I see that now. No, I'm gonna have to take a look at that. That looks very interesting, Blanco. Thank you for the $2 as well. Thank you for both your super chat, your other 2 super chats. I'm gonna have to take a look at that. That looks interesting. I don't know anything about it, so I remember when those cops got killed, but I didn't remember anything else about it. So, can you tell them to fuck off like Jersh did? Yeah. Oh. So, all right, guys. Well, that is it for us tonight. We are gonna get back at it tomorrow. We will be working on things. We'll be doing members only tomorrow night as well. Trying to figure out what we're gonna do for tomorrow. For the non-members thing. So just keep that in mind. And yeah, that is it. If you guys are new, remember we do the Thursday night show. We do it weekly every Thursday night at 9:30. Get to cover a lot of stuff. Birdman got divorced in a very interesting way. The Blue Angels are facing a lawsuit because their flying is, being really mean to some Karens at a nature preserve. LeBron is suing and issuing C&Ds for people who are making AI generated images of him being pregnant, which you're like, well, nobody really believes that, I guess, but LeBron is doing that. And then we got some other stuff we'll be working on as we get going here, but that's Thursday night at 9:30, chat. And yeah, so with that being said, I will see you guys tomorrow. We will do a little bit of model stuff here in a couple minutes. I need to get all situated, and I'll set that stream up right now. Let's see. Hold on. What time is it? Oh, here. Yeah, I'll just set it right now. Live stream. We're gonna keep working on the howitzer. This one's getting kind of interesting, chat. It's being a little redonkulous-tastic. Okay, so we're gonna set this for 10:45. We'll do that. We'll be in here in a couple minutes, chat. So we're all set. I got the so I will see you guys there in a little bit, and that's what we're gonna do. All right, chat. So with that said, remember you coastal alerts are getting folks like crazy. Be careful. Be very careful out there, Darcy. Especially you guys. Be careful out on the coast, chat. There will be the redirect. Yes, there will be a redirect, chat. But just remember, until next time, chat. Just because you did it does not mean you're guilty. Especially if you're Aaron Spencer. You are based. You are based. And Michael Fosler, I hope you burn in hell. Good night, chat. I'll see you guys shortly.
Weapons, blacksmithing, and models of planes, esoteric works, and even some trains. Much merriment had while drinking White Claws, tips on hunting, and even talking the law. Whatever you do, just don't talk to cops, even when they nab you on illegal stops. Just 'cause you did it doesn't mean you're guilty, but please talk to a local attorney.